Hi, I'm Margot Hurlbert, and I'm from the University of Regina, the Johnson Shoyama Graduate School of Public Policy. And today I'm going to be speaking on climate justice, a call for leadership. This talk is about achieving climate justice, which has been elusive. Global emissions have continued to rise, extreme weather events continue to occur with greater frequency, and a legally binding climate agreement, the Paris Agreement, remains yet to be seen. Often part of the problem is the use of vague terms such as environmental or climate justice without a common definition. This paper is going to build a common definition from various disciplines, and it's going to argue that strong leadership from all is required to move climate justice forward. Although defining climate justice is perhaps an exercise in framing utopia, it's important as it can guide nation states, academics, and NGOs into the future. So defining justice as it relates to the relationship between people is challenging. Integrating the environment adds another level of complexity. Climate is an important environmental justice issue as climate and climate change is socially and culturally perceived and constructed. An inequitable global distribution of climate change impacts and adaptive capacity exists. And finally, historic greenhouse gas emission patterns arguably impact and inform the political and legal landscape into the future. No one discipline has a monopoly on defining environmental justice, and as a result, various themes emerge. This paper draws from literature on legal justice, distributive justice, participatory justice, and ethical practice, building a definition of climate justice, and confirms the definition by survey of participants at the United Nations Framework Convention on Climate Change. So defining environmental justice from a legal perspective. Legal environmental justice is enshrined in laws, regulations, and civil court action, which are important for people seeking either redress or compensation from environmental harm and protection from future environmental degradation. Legal environmental justice in relation to climate has two major components. First, it's the justice attained through legal tools and institutions to compensate for harm occurring as a result of climate change and protect claimants from future harm as a result of climate change, especially when there's a deficit in contributory negligence or the contribution of GHG emissions proportionately. Legal justice is also having a legally binding and enforceable agreement on GHG emission reduction obligations, which has a good chance of limiting global warming below the agreed on target of 2 degrees Celsius. In respect of the impacts of climate change, legal actions have been commenced and weathered initial legal challenges, but to date, no successful precedents have been set. Legal opinion confirms a credible case for a legal wrong can be made, and affected countries having a substantive right to demand the cessation of a certain amount of CO2 emissions in order to limit further harm and secure their survival. Several lawsuits in relation to climate change have commenced. The Warsaw International Mechanism for Loss and Damage associated with climate change impacts will help vulnerable developing countries deal with irrecoverable losses and damages from climate change. More needs to be done as legal climate justice has its drawbacks. It is elusive, slow, reactionary, time-consuming, and expensive. Governments are often inactive, and courts are generally not accessible, and often commencing legal action only moves environmental problems to another community. A legally binding and enforceable agreement on GHG emissions reduction obligations would aid in achieving legal justice. Not having a legally binding agreement together with enforceable remedies at the UNFCCC level is a serious shortcoming to achieving climate justice, an item of considerable dissatisfaction of 84% of survey respondents. When asked the respondents the biggest area of dissatisfaction with UNFCCC negotiations, 53% identified the inability to achieve a legally binding agreement. So much rests on the success of the Paris Agreement. Defining environmental justice from a philosophical perspective, distributive environmental justice. Here, climate justice is fundamentally a question of distribution, which would entail a fair distribution of environmental resources or benefits, including carbon-intense activities, and also environmental burdens, including the impacts of climate change from GHG emissions and the ability to adapt. The cause of human-induced climate change is disproportionately attributable to the developed world, which includes Canada, the United States, and Europe, but many of the most severe effects will be experienced by the developing world, small island states such as the Maldives. Some of the countries that will most significantly be affected by sea level rise, reducing their land mass, storm surges, coastal erosion, and compromise of water resources and fisheries on which they depend for food and have the least resources to adapt. Survey respondents allocated obligations for GHG reductions predominantly to countries such as Canada, the United States, Australia, about 40%, the European Union, 30%, China, then the 77%, 20%, the Environmental Integrity Group, 10%, and the small island states in Africa, 0%. A large degree of consensus existed surrounding the minimalistic allocation of any emission reduction obligations to least developed countries, the small island states, the Environmental Integrity Group, and Africa. 56% of respondents believed the specific country should be separated out from the categories that were identified above. Of a total of 180 parties identified by respondents as warranting separation, 30% identified China, 17% the United States, and 14% identified Brazil. All other countries identified had a frequency of less than 1%. The consensus identified in the survey draws attention to the power dynamics existing at past COPs that have prevented achieving the legally binding agreement and fair distribution of GHG emission reduction obligations. Participants at the COPs need to seriously contemplate this problem. As this degree of consensus exists, the inevitable question arises, why has a legal agreement been so hard to achieve to date, and what might the future of the Paris Agreement bring? Defining environmental justice from political science perspective, participatory environmental justice. Participatory environmental justice offers a solution to the shortcomings of legal and distributive justice by allowing people to participate and decide in the distribution of resources, benefits, costs, and pollution, or the democratization of political institutions and processes for decision-making. Participatory climate justice at the UNFCCC arguably entails a conference of the parties in which all countries, NGOs, and people participate, have their concerns addressed, and ultimately contribute to and endorse decisions of the UNFCCC. First of all, countries need authentic participation, and then the participation of NGOs and other civil society organizations need to be incorporated. Survey results reflected the dissatisfaction of respondents as a result of being excluded from COP negotiations by powerful state actors. 61% of the respondents did not feel their country adequately contributed to the COP outcome. The reasons were weak leadership and inadequate representation, politics, including both domestic and international, the interests of rich countries and corporations, and the predominance of a neoliberal ideology, and the undermining of the process by small groups of powerful countries. When asked the open-ended question of what ideal participation for the respondent's country would have entailed, responses of about almost half of people said the process should be changed. Significant themes were strong and better leadership, better cooperation, improved dialogues and meetings, increased involvement of advisors or experts, more participation of civil society, and more democratic selection of delegates. Several respondents wanted a contact group to be formed to study new protocols under the UNFCCC and suggested protocols including deliberation on specific environmental proposals earlier in the process, incorporating multi-track negotiations, as well as increasing opportunities for member states to negotiate quietly in the corners to reach small bilateral agreements. A new vision of leadership and consensus at the COP is required. A total of 18% of the respondents in the survey agreed more resources for smaller countries to participate and more discussion about cases rather than numbers were needed at the UNFCCC. Another respondent stated ideal participation would be to strongly defend the consensus of climate change in a way that supported and aligned with developing nations meaningfully rather than just protecting the United Kingdom interests as part of the G8 EU blocs. It was sadly more of the same from a nation that has a historical and current responsibility for global warming. Participatory environmental justice recognizes and provides for respectful recognition of diverse perspectives and knowledges, not always described as scientific, but as traditional. Meaningful participation through consultations, feedback, mechanisms, public review processes, and activist modes are important. Environmental justice policy implementation surrounding climate at the municipal and state level evidence a diversity of frameworks in social, historical, cultural, and economic contexts with diverse participatory practices, which needs to be captured within the COPs. Municipalities in Canada, Mexico, and the United States are active in climate initiatives, and a dearth of literature evidences these positive efforts. An emerging movement of coalitions of environmental groups with communities are strengthening communities by defining common interests, uniting people and groups from a wide range of backgrounds, advocating for more equitable and ecologically viable practices. A variety of mechanisms at the municipal level, participatory planning, state level, funding of local GHG reduction efforts as in California, multilateral agreements for GHG reductions with technology exchange and funding of clean energy, new partnerships and tools, carbon markets created by private energy companies and governments, cities, businesses have given meaningful voice and leadership role to a variety of groups. The UNFCCC process needs to capture this diversity in leadership and decision making by linking with different fora where this is occurring. These important initiatives and commitments should inform discussions at the nation-state level and ultimately the international level of the COPs of the UNFCCC and acts as a basis upon which to build similar and further commitments. Through a series of side events, cities for climate protection, provincial, regional governments, private businesses, and communities could contribute to the COPs. Events would allow for sharing of mitigation strategies and policies, and by developing GHG reduction strategies and policies from the ground up in this manner, peer pressure to replicate these targets and measures by other cities, provincial and state governments, private businesses, and communities would occur, and the pressure could drift upwards and be consolidated at the level of the state actors of the UNFCCC. This would counter any powerful state actors' ability to stall negotiations, water down commitments, and ensure the current UNFCCC processes have better results. This proposed process would maintain the UNFCCC's commitments to consensus decision-making, but in a manner facilitating consensus. Employing the revised process, a legally binding and legally enforceable Paris Agreement could be achieved instead of simply an accord and stated commitments. The important presence and contribution of nonprofit and activist groups in determining and constructing environmental climate justice should be recognized. Not only were these groups present in the activities surveyed surrounding participatory processes in the local community and city level discussed previously, but they are also present and should be recognized in more meaningful ways at the UNFCCC level. These groups have a plethora of work, thought, and material in relation to environmental climate justice and often represent the interests of the neediest. Increasing their contribution through participatory mechanisms would advance climate justice. Defining environmental justice using ethics, including an environmental ethical practice. To counter any hegemonic power structures, the participatory processes of engagement must set the stage for the adoption of an ethical practice so that current structures of decision-making don't simply recreate structural inequality. The concerns of the neediest must be taken into account. In respect of climate change, these are the people most vulnerable to climate change as defined by exposure, sensitivity, and adaptive capacity. Within the context of climate justice, and environmental decision-making, the neediest or least favored are those experiencing a disproportionate share of environmental burdens, pollution, and climate change risk that lack capacity to adapt to climate change. As such, a vulnerability-based Lexamon rule suggests that when the neediest are best taken care of, then the second neediest would be taken care of. And if this component is not adopted, a danger of participatory mechanisms for decision-making is the marginalized people continue to be marginalized. The hegemonic power structures continue to operate in participatory environmental decision-making bodies. Adopting a philosophy of the principle of Lexamon, or making decisions accounting for the position of the least favored, neediest person or most vulnerable society, alleviates the potential of hegemony. Pursuing climate justice. In conclusion, climate justice and its ultimate achievement is made up by a legally binding, enforceable agreement incorporating a fair allocation of GHG reduction commitments with a good chance of limiting global warming. This agreement would be monitored by an institutional structure of the UNFCCC in which all countries participate, have their concerns addressed, endorse decisions. In addition, countries' participatory processes should be expanded to give meaningful input to NGOs and civil society organizations. As many state and municipal actors are making significant inroads into mitigation and adaptation, these actions and commitments should build commitments in a bottom-up manner at the COP. Most importantly, all should be guided by the ethical practice of Lexamon, in which the needs of the most vulnerable to climate change are taken care of. In this way, climate justice is constituted by legal justice, distributive justice, participatory justice, and the ethical practice of Lexamon. Survey respondents demonstrated a consensus on these issues. So what is preventing the achievement of these in the Paris Agreement? Thank you for your attention. If you have any comments or questions, please email me at Margot, M-A-R-G-O-T, Hurlbert, H-U-R-L-B as in Bob, E-R-T, @uregina.ca. Thank you.